Good afternoon. Thanks to all of you for joining us. We're going to get started in just a minute, and I will start with a few announcements. As a heads up, the PowerPoint materials that our presenter, Jackie Prats, will be going through today will be emailed probably by the end of the week. So you will get a copy of that from the Florida Bar. And then we do have some upcoming events that I'd love to share with you. The next upcoming CLE event that we have is October 16th and 17th. That's the Public Employment Labor Relations Forum. That's in Orlando next week. On November 17th, we will have a webinar on conducting workplace investigations. January 15th and 16th, we will have our annual update and certification review, and that will be in Tampa, Florida at the Le Meridien. On February 27th, we will have Legally Wild, what attorneys need to know about workplace investigations in animal welfare organizations. And then on April 30th and May 1st, we will have our advanced labor topic seminar, and then that will be at the Margaritaville Resort down near Fort Lauderdale. I think technically it's called Hollywood, Florida. So I'm sure we have people still trickling in. Just as a reminder, as I mentioned at the beginning, you will receive the PowerPoint materials by the end of the week. All right, let's go ahead and get started. So my name's Alicia Kepke. I am the CLE director for the Florida Bar Labor and Employment Law section. We're very happy to have you all join us today. This is Wage and Hour 101, and our presenter is Jackie Prats. I have had the pleasure of working with Jackie Prats at Trenum Law for 10 years now. Jackie graduated summa cum laude from Stetson College of Law in 2015. She served as the executive director of Stetson Law Review, and she also received the Darby Award for Leadership and Dedication and the Weehole Award for Best Performance and Trial Advocacy. She's been working at Trenum since she started her legal career, and she's received numerous distinctions, including Best Lawyers in America, Super Lawyers, Legal Elite, Up and Comer, and Author of the Year for the Florida Bar Labor and Employment Law sections check off back in 2020. She practices almost exclusively in employment law on the management side, and I know that she will give a fabulous presentation to you today. So with that, I'll turn it over to you, Jackie. Thank you.
Thank you so much for that lovely introduction. Welcome, everybody. Thank you so much for joining us. Let's see as I share my screen with you all. So today's presentation is designed really to be sort of a 101 level roundup of Florida and federal minimum wage law. So what that sort of means as well is that there's a lot of stuff that is not going to be covered by today. So that includes things like the tip credit, which is a complicated animal. There's a bunch of exemptions from the minimum wage and overtime requirements. This one doesn't talk about unpaid common law unpaid wages claims. Happy to answer questions about that afterwards. But I just want to, make sure that when you leave today, you are prepared to sort of, look at issues using the tools that hopefully you get from today's presentation, but also keep in mind that there is a larger universe out there that you may also have to consider. So with that, welcome to the wide world of Florida and federal minimum wage law. On the federal side of things, the Fair Labor Standards Act is the monster that keeps everything on the rails. That is administered by the US DOL. Among several other things, it establishes the federal level minimum wage and overtime pay requirements, as well as a slew of related record keeping and notice requirements. It includes protections, including retaliation protections for employees for things like, reporting violations of the statute. The FLSA Fair Labor Standards Act. So I'm going to use that acronym a lot after this slide, FLSA, has normally a 2-year statute of limitations, which sort of translates to a 2-year look back period for plaintiffs, unless there's a willful violation, in which case that becomes a 3-year look back period. Damages that are possible include lost wages, liquidated damages, attorney's fees and costs. Those are the 3 probably most common types of damages. When we get into retaliation claims, emotional distress and mental anguish damages become available. And civil money penalties are available because the DOL, as part of its administration duties, investigates and sometimes can enforce the statute. So a DOL investigation can result in civil money penalties. Something to keep in mind as you sort of leave today is that unlike most employment statutes, the FLSA makes it possible to bring claims against individual managers and supervisors. That's just because of the incredibly broad definition of employer under the FLSA. The FLSA also allows for multi-plaintiff actions, but they are collective actions as opposed to class actions. I'll talk about that for just like an extra second a little bit later. Settlement of FLSA claims is also kind of a monster. Unlike most other employment statutes and most other employment claims, settling sort of quietly out of court is on the difficult side because most of the time a settlement of an FLSA claim has to be approved by a court or by the DOL or arguably a court. There are some sort of shifts and changes in that case law right now. It's a little bit in flux, but you should assume that an FLSA claim settlement agreement needs to be approved by a court or the DOL. On the state side of things, the Florida Minimum Wage Act and Article 10, Section 24 of the Florida Constitution sort of work hand in hand to create Florida's minimum wage requirements. It being the Florida Minimum Wage Act is based heavily on the provisions of the FLSA. So most of the same standards apply, most of the same requirements apply, most of the same remedies are available. And the same goes for employee protections, vis-a-vis retaliation, et cetera. There are some key differences between the two. First and foremost, the FLSA requires employers to pay employees at least the applicable minimum wage per hour, non-exempt employees. The applicable minimum wage varies by state. And in Florida right now, it's $14 an hour. It will increase to $15 an hour next year. The Florida Minimum Wage Act does not have its own sort of separate overtime schema. It's really limited to minimum wage. It has a significantly longer statute of limitations, 4 years for normal violations and 5 years for willful. Collective actions are not permitted under the Florida Minimum Wage Act. Class actions are. And the differences between class and collective actions is super complicated and well beyond the scope of this particular presentation today. But probably the most significant one is that class actions are opt-out. The class sort of becomes its own legal entity that a plaintiff has to do something to get out of opt-out. Collective actions are opt-in. They don't become the same kind of like legal entity that a class does until it varies. You know, certification is a good benchmark for that. But the difference between opt-in and opt-out has a series of kind of rippling implications. So something to flag in your mind as you sort of analyze this issue, that class and collective actions really should be treated, different accordingly. Okay. So coverage under the FLSA, very similar to coverage under the Florida Minimum Wage Act. The way that I have actually explained this to clients sometimes is that you should assume that you are covered under the FLSA. Every now and then you'll come across an employer who, I'll talk about this in just a second, who isn't covered. You'll come across an employee who isn't covered, but it's rare. And you can see here that the definition of employee is to suffer or permit to work. An employee is any individual who's employed by an employer. An employer is anybody acting directly or indirectly in the interest of an employer in relation to an employee. It's all very broad, it's all very circular, and that's all by design, because it's a statute that's designed to cover as much as possible. A few exceptions to that are independent contractors, volunteers, interns, and trainees. Each of those little exceptions to that rule are determined by a multi-factor test that is fact-specific, not only depending on the category, volunteers versus interns versus trainees, but also dependent on the totality of the circumstances. Coverage, that's what I was hinting at just sort of a second ago. An employer that has 2 or more employees who are engaged in commerce, has more than $500K in annual sales or business, and engages in commerce or the production of goods for commerce. Every employee of such an employer is covered. As you can see, that is very, very broad. And even if the employer itself isn't covered, an employee can be individually covered if they engage in interstate commerce or the handling or production of goods for commerce. And that can be something as innocuous, I guess, as, engaging in communications with vendors or customers over the internet or using credit cards. Very, very broad. Going in, the assumption should be the employer and or the employee is covered. Okay. So once you sort of get over the hump of, covered, employees are sort of divided into 2 camps under the FLSA, and this is much less relevant for the Florida Minimum Wage Act, because so many of what I'm about to talk about have more to do with overtime than minimum wage from a practical perspective. But many of these exemptions apply to the requirements under the FLSA for both minimum wage and overtime. This is to say that the buckets of non-exempt and exempt employees are going to roughly apply under the Florida Minimum Wage Act as well. Non-exempt employees are the default. Non-exempt employees are subject to the minimum wage requirements of the FLSA and the overtime requirements of the FLSA. Non-exempt employees must be paid at least the applicable minimum wage for all hours worked, and non-exempt employees must be paid overtime compensation for every hour worked over 40 in a work week. A very common misconception amongst employers is that if I pay my employee by the hour, they're non-exempt, and if I pay my employee by salary, they're exempt. Be aware of that misconception. It is far from true. Non-exempt employees can be paid by the hour, by the salary, by day rate, by piece rate. Exempt employees, it's a little bit more restricted, but there are still a variety of comp structures that you can pay an exempt employee with. So keep that in mind. Okay, with regard to non-exempt employees, one of the more common issues that comes up is whether a non-exempt employee is being paid for all of the time they actually work. All hours worked, or rather the requirement that a non-exempt employee gets paid at least the applicable minimum wage for all hours worked includes, with very limited exceptions, being paid that applicable minimum wage for all activities that occur between the beginning and end of an employee's principal activities on a workday. So that should not be equated to, the employee shift or what the business's normal operating hours are. Business hours and employee shift and actual hours worked by the employee are not necessarily the same thing. Activities that happen before an employee's scheduled shift, for example, that are indispensable to the activities that will occur during that shift, or after the shift, preliminary and post-preliminary activities, are also compensable. So often that includes things like donning and doffing, putting on, taking off PPE or other necessary clothing or equipment. That can also include sometimes travel time. Most commonly, that's travel time like between work sites. Commonly, that does not include your normal commute from home to work. Under some limited circumstances, it can, normally no. Waiting and on-call time can be compensable as well. So the main distinction there is an employee who is engaged to wait is normally going to be owed pay for those hours. An employee who is waiting to be engaged normally will not. The distinction between waiting to be engaged and engaged to wait can be a fine one. And like most things under this schema, unfortunately, is a sort of fact-specific, circumstance-dependent determination. After work, trainings, meetings, events can also be compensable depending on, the nature of the training or the meeting. Important to remember also, this is also a common problem that we see is managers or supervisors who ask non-exempt employees to do, minor tasks during their lunch break, for example. Interrupting a meal break with work can make the entire meal break compensable, whereas it would have been unpaid before, depending on the circumstances. So meal times can be unpaid for non-exempt employees if they're uninterrupted. Otherwise, you can get into trouble. The general rule is work that's done on an employer's behalf. So training, work events, doing work during a meal break, for example, needs to be compensated, even if the work wasn't authorized. So employees can get their employers into hot water sometimes if they have a habit of like working off the clock. They show up to work and they start doing some of their pre-shift responsibilities and wait to clock in until later. If the employer knows that they're doing that, that is suffering or permitting them to work. If you recall back to the slide that defined what employee meant, that is generally compensable time. And failing to pay the employee for that time, even if they weren't asked to do that work before shift, can lead to an FLSA violation. Okay, overtime. The general rule, and this is for non-exempt employees, is that time and a half, 1.5 times their quote regular rate of pay is owed to the employee for every hour they work over 40 in a work week. Regular rate is can be sort of a confusing term. It is a term of art. It does not just mean the employee's base rate. Regular rate, as that term is used under the FLSA, means it's the excuse me, the product of putting all of the employees' remuneration in a work week. So discretionary bonuses, commission, normal hourly wage. That can include things like production incentives. Almost all remuneration that an employee earns in a work week goes into a bucket, and that bucket gets divided by the total number of hours the employee worked in that work week. And the product of that determination is the regular rate. And it's that gets multiplied by 1.5 to get the overtime rate. And that's what a non-exempt employee normally gets paid for hours worked over 40 in that work week. There are some exclusions, gifts, things like paid leave, expense reimbursements, that does not go into the bucket. Most things do go into the bucket. There are sort of a series of other like alternative forms of overtime payment that depend on the type of work the employee is doing, or depend on the the type of employee the employee is. You can have, for example, it's called piece and a half, which is dependent on a piece rate as opposed to an hourly rate. Piece rate is, the employee gets paid X number of dollars for every unit of work they do or every widget they produce, as opposed to X number of dollars for every hour they work. There are certain pay structures that allow an employer to pay a half-time premium as opposed to time and a half. Unfortunately, if we slow down to sort of talk about every potential mathematical way to do that, we would probably be here for like another week. So we're not going to do every possible way to calculate overtime, but the basic general rule of thumb is time and a half for hours worked over 40. All right, so that's non-exempt employees. That's sort of bucket number one in terms of employee treatment under the FLSA and Florida Minimum Wage Act. Bucket number two is exempt employees. There are, I don't think I've ever sat and counted them individually. I think there are probably more than a couple dozen individual types of exemptions under the FLSA. I've got a list, I'm not going to go down the bullet point list here, but you can sort of see examples. I think wreath makers are an example of an exemption that doesn't happen to be included here. You can be exempt from the minimum wage requirements, from the overtime requirements, or both. The most common exemptions that most people probably deal with on a day-to-day basis are called the white collar exemptions. That includes these listed here. So executive, administrative, professional, computer, and highly compensated employees. All of these exemptions have like minimum compensation requirements that most of them include salary. Some of them also allow fee payments. Computer allows a much higher hourly rate. Outside sales employees don't have the same sort of compensation requirements. So we'll talk about it in a second, but outside sales employees are sort of designed to be commission only. The key thing to remember, actually, you know what? Let's talk about salary basis. So a second ago, I sort of talked about most of the white collar exemptions require or allow an employee to be paid on a salary basis. Some allow fee basis, computer employees allow hourly. By and large, in the wild, most of the time you're going to encounter employees who are classified under these exemptions who are paid on a salary basis or who are supposed to be paid on a salary basis. And basically, basically that is a salary supposed to be a predetermined amount that doesn't change based on quality or quantity of work. It has to meet, right now, the minimum threshold is $684 a week. That changes, and when it changes is usually subject to significant litigation challenges. So right now, I think we're holding steady at 684. Stay tuned. That could be changing kind of at any time. The most common issue that comes up with regard to the salary basis test, really salary basis period, is improper deductions from that salary. Very, very limited deductions can be made from the salary of an exempt employee without destroying the exemption. Probably the most common one that I have seen is attempts to recoup for things like a negative leave balance or damaged or lost equipment. Employers trying to take that loss directly from the pay of an exempt employee can have the result of destroying the salary basis, which in turn destroys the exemption, which if the employee is working over, regularly working over 40 hours a week, the most common thing that happens is suddenly, depending on how widespread that type of violation is, suddenly you can be looking at an employee who you thought was exempt. As it turns out, their exemption was undermined or compromised or even destroyed for however many pay periods those deductions were occurring, which can suddenly result in, a lot of owed overtime. So the permissible deductions, there are what did I say? Six enumerated permissible deductions that comes directly from the statutes and regulations. If you keep in mind that partial day absences can almost never be deducted except for in the case of like FMLA leave, which is that's an entirely different animal. Happy to answer questions later, but different animal for the purposes of our presentation today. Full day absences can be deducted for personal reasons in connection with a bona fide sick leave policy. And you can also deduct in the case of like the employee's terminal, it's called the terminal or initial week of employment, where if an employee starts work on a Wednesday, normally you have to pay the entire week's salary. If they start on a Wednesday, you don't have to pay Monday or Tuesday. They weren't employed at that time. Likewise for the terminal week, if they get terminated on a Wednesday, you don't have to pay them for Thursday or Friday. Otherwise, the general rule is if they work during a work week, they normally have to be paid for that work week. One-off mistakes here and there can be salvaged if the employer follows the requirements of what's called the safe harbor provision in the FLSA. So with a clearly communicated policy that describes how to make a complaint, ensures that the employee is reimbursed for any improper deductions, and communicates in the policy, and in fact also makes a good faith commitment to not repeat the violation. One or two violations of that prohibition against certain deductions doesn't necessarily destroy the salary basis, but that's not something that an employer can depend on again and again and again. That starts to not look like good faith commitment to comply in the future. It's not something that's meant to save a practice of impermissible deductions. All right. The duties tests for the exemptions under the FLSA are, I think, hands down the stickiest issue encountered by most employers who run into issues with misclassification of their employees as exempt. So there are generally 3 sections to the test of whether an employee is exempt or not. Section 1 for most of the white collar exemptions is, are they paid on the correct basis? Salary basis, fee basis. For the computer employee, like I said, the high enough hourly rate will also get you there. So are they paid on the correct basis? Are they paid at least the minimum pay? So for most, that's a salary of $684 a week. Minimum, computer minimum hourly. There are some exceptions to that, but that's salary basis, salary minimum, and then the duties test. The duties test changes depending on, varies exemption to exemption. Like everything else, unfortunately, under the FLSA and, as a result under the Florida Minimum Wage Act, this is a very, very fact-specific determination. So let's use the executive. We'll jump in with the executive. We'll talk about each of the white-collar ones, but jumping in with the executive. So if an employee's primary duty, and the primary duty is not just, sort of marginal duty or, a minor, unimportant, trivial duty. It's got to be the primary duty is sort of the reason for the employee's employment. So an employee whose primary duty is managing the enterprise or managing a customarily recognized department or subdivision in the enterprise, that employee can be exempt under the executive exemption if they are regularly and customarily directing the work of 2 or more full-time employees or their equivalent, and they have the authority to hire or fire other employees, or have the weight of their recommendations as to hiring, firing, discipline, advancement, etc., are essentially taken seriously. So an executive exempt employee does not have to be the very tippy top of the totem pole or the food chain, but their recommendations do have to be taken seriously by whoever is above them on the food chain. And the requirement that they regularly direct the work of 2 or more other full-time employees or their equivalent. I just want to come back really quick to the or their equivalent part of that requirement there. You can have an exempt executive employee who supervises a small department of, for example, 4 part-time employees, 4 employees who work 20 hours a week. If they only supervise a department with 3 employees who are part-time, 3 employees who work 20 hours a week, that essentially comes out to 1.5 full-time employees. So that kind of a small department is not going to be enough to push an employee over into the executive exemption. That is a surprisingly common issue that comes up. All right. I want to make sure that we're sort of getting close to running out of time. I want to make sure that we definitely talk about the administrative exemption, because that for sure, I think, is the exemption under the FLSA that sees the most litigation, and is probably the hardest to understand. So administrative employees have a primary duty that is the performance of office or non-manual work. That part's easy. That is, quote, directly related to the management or general business operations of the employer or the employer's customers, and includes, quote, the exercise of discretion and independent judgment with respect to matters of significance. So those are, as I'm sure you can see, very squishy, for lack, that's a professional term, squishy. Um, they're vague, difficult to define. Um, the way that the way that I sort of conceptualize this and the way that I explain this to clients to help them conceptualize it is employees sort of technically this is an outdated distinction, but it comes up in current court opinions all the time. And it's the administration production distinction. So a good rule of thumb is if your company is Acme Widgets Inc. and you have a factory floor and the employees you've got employees who work on the factory floor making the widgets physically, those are production employees. They are making the widgets is the point of Acme Widgets Inc. So sort of the core of the reason for the business model. The employees who are creating the good or the service that is the core of the employer's business model, those are generally going to be your production employees. That's essentially mutually exclusive with employees who are on the administrative side of that divide. Administrative employees are the ones who make sure that the production employees are getting paid on time, have a safe and healthy workplace to report to, have proper health insurance, are making sure that the production employees have materials to work with and their machines are working. Essentially, employees on the administrative side of that divide are sort of making sure that the production employees have an infrastructure within which to work. They make the trains run on time, but they're not creating the good or providing the service that is the core reason for the existence of the business. You won't find administrative employees on the floor of Acme Widgets Inc., contributing directly physically to the hands-on work of the production. Obviously, so many employers in this economy are, service-based. Like we're increasingly moving towards a knowledge-based, service-based economy. So that distinction becomes sort of unfortunately less and less useful literally, but it's, I think, still a really useful way to conceptualize it and help employers understand, the kind of difference that we're looking at. Okay. It's going to step through some of these a little bit faster because I know that we are getting towards the end here. Professional exemptions. There are, broadly speaking, two sort of classes of professionals. Professionals still have to be compensated generally on a salary or fee basis at least $684 a week. You can either have a learned professional or a creative professional. Learned professionals have to perform work that requires advanced knowledge in a field of science or learning that is customarily acquired by essentially academic instruction. If an employee has, or rather, if the employee's job requires them to have a certain degree, postgraduate especially, sometimes graduate, there's a good chance that they could qualify for professional exemption. So classic examples are, lawyers, doctors, accountants, engineers, architects. Notably, lawyers, doctors, and teachers of the sort of classic quote unquote learned professionals. Lawyers, doctors, and teachers are not subject to that salary basis or salary threshold requirement. So we can sort of be paid. That's the way that we are paid is not governed necessarily by the FLSA. For creative professionals, that is work that requires invention, imagination, originality or talent. And your classic examples are things like actors, musicians, painters, classical type artists. Highly compensated employees, if you can, these are easier to analyze in the sense that there are really sort of, practically speaking, really sort of two major, prongs of this test to hit. Do they make at least $107,432? Doesn't have to be salary, doesn't have to be any particular compensation structure. Just do they make that amount? It has to, this is still a white collar exemption, so their primary duty still has to be office or non-manual work. So really highly skilled, highly compensated tradesmen, carpenters, unfortunately, are not going to fall into this exemption. But assuming that we are still talking about a white collar employee, as long as they customarily and regularly perform at least one of the exempt duties or responsibilities of an exempt executive, administrative, or professional employee, they can be exempt. Computer employees are, this one's kind of tricky because I think a lot of folks have this misconception that if you have an employee who works like at an IT help desk or who helps with network administration, they're going to be exempt. That is a misconception though. So number one, to be an exempt computer employee, you have to meet the compensation requirements. So salary or fee of at least $684 a week, or at least an hourly rate of $27.63 an hour. And their employment as a computer related employee has to be sort of a development or design or creation character. So somebody who is, designing a network, designing an app, helping to troubleshoot or test a software or an app, before it goes live, more likely to be exempt computer employee. Someone who is kind of troubleshooting a well-established system, somebody who is, the lowest level help desk who has to escalate more complicated problems higher up, less likely to be doing the kind of computer related work that would make someone exempt under this exemption. Okay. Outside sales. So I think the easiest way to understand an outside sales employee is to sort of understand where this came from. Outside sales, the outside sales exemption is designed for folks who do literally door-to-door sales work. Door-to-door vacuum salesmen, people who used to go to door-to-door and sell like encyclopedia sets. They're out of the office and away from headquarters so often it becomes difficult or impossible to track their hours. So there is no particular compensation requirement. From a practical perspective, what that usually looks like is 100% commissioned employees. Not necessarily always, but most commonly. And these outside sales employees have to be customarily and regularly engaged away from the employer's place of business. And keep in mind that the place of business does not equate to the employer's office or the employer's like physical facility or headquarters. More and more commonly, you're having employees who do outside sales adjacent work, but they work remotely from their home office, sometimes not even in the state where the employer is located. If that employee is doing most or all of their sales work from their home office, making calls or sending emails or doing social media networking, that employee, there's a good chance they're not actually exempt as an outside sales employee. If they're out sort of hitting the pavement, meeting people in the community, going to networking events, much more likely that they are outside sales than than someone who is sort of always, sitting at their home desk. Okay. And the final thing that I wanted to hit here is record keeping requirements. So in addition to obviously the payment requirements, employers need to make sure they are keeping key records for every employee. So, like I said, or I'm sorry, not like I said, like Alicia said earlier, this PowerPoint is going to be available to you later, so I'm not going to go through the specific bullet points here for everybody, but these full name and social, etc., these need to be kept for every employee. For non-exempt employees, employers need to make sure they are keeping records of the hours they work every day, the total hours they work every week, the basis on which they're paid, which means our hourly rate, piece rate, day rate, etc. Whatever that basis on which they're paid, whether it's hourly, piece, salary, day, what have you, whatever that breaks out into on an hourly basis, because the hourly basis is the foundation of the overtime calculation. They being employers also need to keep track of the total daily or weekly straight time, which is to say hours, 1 through 40, and overtime pay, hours above 40. And additionally, additions to or deductions from wages every pay period. Now, your normal payroll deductions, that's easy. But that also includes things like, reimbursements for expenses, for example, like, pizza delivery drivers. There has been a ton of recent litigation with pizza delivery drivers who claim that they're not being adequately reimbursed for, gas and depreciation of their vehicle and maintenance costs, etc. Reimbursements for that need to be kept track of each pay period. Now, just because an employee is exempt doesn't mean the employer is off the hook. The employer doesn't have to keep track of the same, granular detail that they do for non-exempt employees, because normally for an exempt employee, you're not keeping track of how many hours they work, because normally they're paid on a salary or fee basis. But the employer still needs to keep track of enough information so that the employee's total remuneration can be calculated. So there's a little bit flexibility there, but if they're getting bonuses or if they make commissions or they're getting incentive payments, all of that still needs to be kept track of each pay period. All right, and with that, let's see if there are any questions.
All right, we don't have any open questions yet, but for those of you that are watching this presentation, you should see on Zoom a Q&A button at the bottom of your screen. And so if you have questions, you can feel free to put those in and we will answer those. If not, you can always reach out to Jackie separately after the fact. It's Jackie Prats at Trenum. So why don't you go ahead and give your actual phone number?
Yeah, let me, I wonder if I can quickly reset. So my email is jprats@trenum.com, and my office line is 727-820-3954. And that information is also like on the title slide of these materials. So when you get those materials, you've got my contact information as well. Happy to answer any questions that you may have.
All right, and we have two questions. So first question, what are the most common industries that you see with overtime violations?
Ooh, okay. With overtime violations, I hesitate to break it down on industry lines, because probably the most common overtime violation I see is with people who have been misclassified as administrative exempt. So unfortunately, that's not industry specific. That's, do you have someone who works in HR or payroll or accounting, but they do sort of rote clerical work? That's probably not exempt. And it also can run people into trouble with like frontline management, like lower level management employees, who supervise employees who are definitely production, like your floor supervisor of Acme Widget Inc., who has some scheduling and admin duties, if they're also out there, hands-on doing some of that widget manufacturing work, may not be exempt. So that's probably the most common one I see, and that's sort of like cuts across many, many industries.
All right, next question. For record keeping, is there a general time period you recommend to keep records for former employees?
Well, what I recommend or not is less important than what is required by statute. There are tiers of requirements. I think most records required to be kept under the FLSA, I think, have a 2 or 3 year retention period. There are others that are longer than that. I can, if you reach out to me with your contact information, I can send you like a more detailed list, but I don't want to just spout it off to you because it is specifically enumerated in the statute.
Another thing, if you don't mind my jumping in, is with the Florida Minimum Wage Act, if it's willful, it can go back 5 years, right? And not willful 4. And so if you don't maintain records for that period of time, then you could be stuck in a situation where a former employee or a current employee is bringing a claim alleging you failed to pay them minimum wage and you haven't maintained the records for the period of the statute of limitations. So I would say 5 should be a minimum, but obviously you could double check the regulations and see if the requirement's longer. All right, we have another question. You said that employers have to keep track of regular versus overtime hours. Do they also have to specifically categorize the hours and rate of pay on an employee's paycheck?
I assume by on the employee's paycheck, I mean, you mean sort of like the actual like pay stub that the employee receives, or if they're getting direct deposit on their electronic pay stub.
Yes, that's what she's asking.
Right. You know what? I am blanking on the answer to that question. I know obviously they have to keep that information, you have to keep track of that information. And certainly there is information that has to be provided on the employee's pay stub. The specific question of whether the employer has to provide the straight time versus the overtime on the pay stub, I'm not sure if that's a requirement. I can say that it's very, very common. And if you use, one of the major payroll companies like Paychex or ADP, usually they will do that for you. But if you, again, like give me your contact information, reach out to me, and I can get you a more conclusive answer on that.
I think, Jackie, that your slides reflected the information must be maintained. What you're saying is you just don't know if that has to be actually on the pay stub specifically.
Exactly.
Or if
Yes.
you maintain it separate from the pay stub.
Right, exactly. Absolutely has to be kept as a record for sure. Whether it needs to be also in whether the employee has to receive regular notice of that on their pay stub of that particular question, I'm not totally sure. That's the point I've got to get back to you on.
Okay. Next question. You said that if you terminate an employee who's exempt on a Wednesday, that you would have to pay them for the entire work week if it's Monday through Friday. Is that correct?
No, I'm sorry. I maybe I sort of garbled my words, but if you fire an exempt employee midway through the week, the terminal and initial weeks of an exempt employee's employment are exceptions to the general rule that they have to be paid a whole week if they work at all during work week. So an exempt employee who's terminated on a Wednesday only has to be paid through that Wednesday. They do not have to be paid for Thursday and Friday under, unless there's some kind of like contract involved, that takes you beyond those normal requirements.
Yeah, and I think that's a really good caveat to remind everyone. What Jackie's been talking about is the Federal Fair Labor Standards Act and the Florida Minimum Wage Act. Obviously, employers can contract and promise more than those laws require, and then you can have a breach of contract claim if you don't abide by what you promise. So if you promise an employee you're going to pay them 90 days after they stop working, that you're gonna have a breach of contract claim if you don't do that. But per the wage and hour laws Jackie was discussing, you would not. And then the other thing to bear in mind is that there are state and local laws outside of Florida that have higher requirements. So for example, if Jackie was talking about how you could have an unpaid break, lunch break for a non-exempt employee, could be that a state outside of Florida where that employee works would actually dictate that you pay that. All right, I believe that we've answered all the questions. Let me just double check. I believe that's it. So just as a reminder for everyone, thank you very much for attending. If you have suggestions on additional topics that you would like the Florida Bar Labor and Employment Law section to cover, please feel free to reach out to me. I'm Alicia Kepke at Trenum, and that's akepke@trenum.com. But also you could go to our website, the section's website, or my firm's website, and find the information there. And also you can find the dates of our upcoming webinars and our upcoming in-person CLEs there as well. And I went through those at the beginning of the program. But just as a reminder, what we have next week, we have an in-person CLE in Orlando. And then we have a webinar coming up in November relating to workplace investigations. We have an in-person 2-day seminar in Tampa in January, and then we have our advanced labor topics seminar later in the year. And for some reason now it's not letting me pull back up that announcement to share those dates with you again. So hopefully you got them at the outset, but there we are. Okay, October 16th, 17th, that's Public Employment Labor Relations Forum. November 17th, Conducting Workplace Investigations. January 15th through 16th, the Annual Update and Certification Review. And then we have Advanced Labor Topics, April 30th to May 1st. All right, we just got a question. Are you sending out the slides? Yes, you'll receive those by the end of the week. Will you be sharing a CLA code for credit purposes? That is an excellent question. My guess is that that was included initially in the actual registration form, but if not, then you likely would receive that when you get the materials. And if you do not, feel free to reach out to me to let me know. Any final questions? Oh, there we go. Someone added it. Thank you very much, Michelle. The CLE is 9407. Again, that's 9407, and that is listed in and it was in the email with a link. Thank you all for chiming in to share that. So CLE code 9407, also in the email where you received the link. Great. Well, thank you again, Jackie, and thanks to all the rest of you for attending, and we hope to see you soon. Goodbye.